Well, hello. Welcome to Land Title Talk, where we encourage you to text your questions or comments in at 904-501-4481, or you can email us at stephen@golandtitle.com. That's Stephen, STEPHN, at GOLAND, title, TITLE.com. Glad to be here with you. I have with me my esteemed guest, Rusty Collins from the Law Office of J. Russell Collins. And we also have Julie Settle here from Land Title America, keeping us in line, answering questions, and just making sure if we start veering off, she pulls us back in. And again, I'm Steve Collins from Land Title. We're glad to be here with you. So Rusty, dare I say what's going on in your world?
Not a whole lot that I can talk about.
Good, because you know me, I have plenty to talk about. So today I want to talk about mortgages. I wonder why. Let's give you a little scenario. And, you know, I think I'm pretty good when it comes to mortgages. I want to go with, hey, a friend came to you and said, hey, I want to borrow some money, example. Okay, that's what I want to go with. Let's just say that, I don't know, we have Steve Collins here and I need some money, okay? And I go to Julie, I say, Julie, will you loan me, I don't know, $5,000. And I'm willing to pay Julie 25%. No collateral, just a promissory note. Any issues?
Well, if we're talking about a written document, especially a promise to pay,
Yes.
yeah, there's lots of problems.
Tell me what?
Well, first of all, 25% as an annualized rate is usury in Florida.
What does that mean?
It means it's a crime. Well, 25% is not 25% or less is not necessarily a crime. It's what they call civil usury, and I think the statute says you lose double the interest.
Well, what does that mean? I lose double the interest.
Well, if you're supposed to get $10 in interest on that amount,
Okay.
you could lose $20 worth of interest. You'd lose $20 worth of the payoff.
Okay. Okay. So
That's
my
the wrong
interest
number. You
Why?
said $5,000.
Oh, I said $5,000.
Mm-hmm.
I need to write down my numbers better. All right, $5,000. All right. So if I have $5,000, okay, and I'm going to charge a 25% interest, right? Which means my interest rate's going to be $1,250, right?
Okay.
All right. And Julie gets all wise on me and goes to an attorney like the Law Office of J. Russell Collins because her and Steven got in an argument and she feels like I'm being a butthole and she doesn't want to pay that $1,250. What would you do in that situation if I charge her a 25% interest rate? It's noted by virtue of a promissory note.
Mm-hmm.
Okay. What could you do in that situation for Julie?
Well, first of all, you got to figure out how much has been charged over the 18% you're allowed to charge.
Okay. So
Okay.
18% is now I thought there's a difference between consumer debt and real estate debt.
No,
And maybe they're the same, but they're different, right?
They are the same.
They're the same. Okay.
In some states, though,
Delaware. No.
Washington.
Is it Washington?
And Washington
All of our
State.
credit cards come from what state?
Oh, well, they come from wherever, but they're always national banks, I think.
Okay. Because they get away with charging you 32%.
The feds are different than the states.
No. Okay. If I
State
get a
law
credit
doesn't-
card
Mm-hmm.
with Discover,
And Discover is a national bank.
they're a national bank. Okay.
Therefore, they're controlled by the Fed.
Okay. So what's usury for them?
They don't really have a usury that. Now, credit card rates are dealt with separately, but there's
So
no
a credit card
usury.
company can sit there and charge me 50%?
No, credit card companies can charge you, I think, 29.98. I think that's the max. right now.
32 is what I saw. I saw
Okay.
32%.
Okay. That might be a default rate or something, but
Okay.
now, so you've got that because it's federally controlled.
All right.
The
And
states
obviously,
have no control over that.
Okay, so states can't mess with credit card companies because they're federal.
That is why all of your credit card companies are national banks and not state banks.
Because if they were state banks,
You'd be limited by usury.
so Ameris Bank,
Ameris Bank does not run its own credit card. It's through Elon,
gotcha.
and that's a national bank.
Okay, gotcha.
Okay, that's the key to that
Okay,
difference.
all right.
But so on your $5,000 example, 25% interest for a year is $1,250, right?
Right.
18% interest would be $900.
Okay,
So unless if you got caught with that situation, then
which I did because she went
Right.
to you, running to you.
so you could owe like a $700 refund because it's double the difference.
So a $700 refund. Now, what if she didn't pay the interest at all?
I don't care if you pay it. I only care about the agreement.
The agreement says that after 1 year, she'll owe me the $5,000 and $1,250. The year comes, Julie's like, not paying it.
That works for me. And I don't care if you paid it. I care
Okay,
if you
so
charged
now she hires you.
it. Mm-hmm.
I charged it, but I didn't collect it.
Not too
What are
bad,
you going to
so
get
sad.
out of me?
What I'm going to get out of you? We're going to negotiate how much we're going to need to pay off this debt, which would be $5,000, plus the minus the $700.
Minus the $700.
Right. There's $350 in interest, or $350 difference in the interest.
So I owe her so she owes me $4,300.
Yeah.
Okay. So I basically loaned her the money, but paid money to loan her the money by virtue of doing that.
Yeah, but make it 26% interest.
Okay.
She owes you zero.
All right. I'm going to make it 26% interest. So a year passes by.
Mm-hmm.
Julie, I go to Julie. Year's up. You owe me my 26%, which is going to change the numbers there, right? So $5,000 times 26%. Julie, you owe me $1,300 plus the $5,000. She runs to Rusty.
And Rusty will go to court and get the judge to say she owes you nothing and you can't collect it.
So she gets $5,000 for free.
Correct.
Hey, Stephen, can I borrow $5,000?
At 26% interest. That's the important part.
Now,
We'll do it.
at over 25% interest is criminal usury.
So could I be criminally charged?
Yes. Will you be? Don't know.
She turned me into the state's attorney's office.
Depends on what they're doing. I mean,
But it is a state crime.
It is a state crime. It is a misdemeanor. Now, if you get to
26 is a misdemeanor.
anything over 25 is a misdemeanor.
Okay. Anything under 25 is
From 18 to 25 is a civil situation
Just
with double the
civil, okay.
interest.
Okay.
so 18 to 25 is civil.
When you hit the criminal level, it becomes you cannot enforce the debt in any state of any court in the Florida state.
Okay.
And now, if it's 25.01 and you made a miscalculation somewhere, you probably could finagle that. As far
But
as
you're
the
still going to
criminal
have the penalty.
Yeah, the penalty.
Right.
Okay.
In a case of 25%, basically I get to pay her to loan her the money because I'm only getting $4,300 back.
Right. And
With the
that's
penalty.
why you shouldn't be selfish or too creative. Now, part of the usury elements to prove this criminal usury is there has to be a bad intent. You have to have the intent to charge more than the legal rate.
I didn't have bad intent. I only wanted to loan her the money because she's my friend. How's that bad intent?
So he just falls on
At
his sword.
26%.
You just fall on your sword before the judge, mea culpa. Maybe get a slap on
Maybe.
the wrist.
She was my friend. I wanted to loan her the money.
Yeah.
The fact she doesn't want to pay
How
me back.
bad did she need the money?
Well,
I
she
beg
needed it
for
really bad. That's why I gave it to her.
Because you've gotten it anywhere else?
No.
Well,
I have horrible credit.
so she was desperate?
She was desperate,
You
but
took advantage of her desperation?
no, I helped her out.
Stephen.
I helped her out.
Well, if we can prove bad intent,
No, I'm helping her out.
yeah.
That money was making me 35% where I had it. And for me, I had to take a loss to help her. And I was willing to help her out because She needed me so bad, and I was the only one to help her out. She needed to pay a bill, a medical bill, whatever.
Depending on who's trying to enforce it.
She's trying to, well, I'm trying to enforce.
No, I'm saying depending on who's trying to enforce the usury statute. If it was a state
well, in this
agency,
case, it's going to be her and you.
Right. If it was a state agency, I could see them saying, too bad, so sad, you lose. If it's a state court, there's going to be a fight, but if you can show that this was just inadvertent somehow, if you can show that you did not have intent to charge more.
I just didn't know.
Well, but you had intent to charge 25%, right?
Yeah, because I could have got 35%, or I was getting 35% on the money.
Right. So in his mind, he takes a hit.
I'm taking a hit to help
It's
her
high
out.
for me, but he's
if
taking a 10%
you're going to loan money to
hit.
people, you need to know the rules.
That's right. Yes, Stephen.
Yeah.
Know the rules.
Because, okay, so usually when somebody does something that's usurious, they have put together a set of circumstances that shows that they tried to get away from usury but still get the benefit. And that's where that's the big way you show intent, is they had a scheme, they tried to hide it, they called it something else.
Well, okay, let's talk about that then. Okay, in my simple example, I wanted to use simple examples just because I want to boil it down. But let's make it more complicated. And I mean, and it's not that we don't have experience in this arena. Okay, we do. But to explain what you're talking about, if we could simple it down, and I don't know if we can.
Well, let's just make it simple.
Sometimes when we make it so simple, it doesn't make any sense, and I don't want to do that.
Okay.
But I do want to make it simple to explain what you're talking about, because to be truthfully honest, until this last experience that we had just ran across, which we do need to keep that private. That's not anybody's business. I did not take into consideration that other goods and products outside of the loan, if associated with the lender, could be considered a loan fee and therefore put into the calculation of the interest rate, or what we call the APR, or the annual percentage rate.
Right.
That was something I had not thought of ever in all the years I've been in the business, for whatever reason. Okay. But it's an interesting topic. So how do we boil this down to such a degree to where we give a simple example how this could work? Because I could see in my analogy with Julie, I'm like, hey, Julie, I'm getting 35% here. In my mind, 25 is all I can get away with, I think, or 26, we'll say, just for the fun of it, right? And I loan her the money, but I say, and also in return, you're going to, Julie, clean my house every month. And the dollar value of that cleaning of my house while I did this loan, because again, I would have made 35%, okay? While I'm doing this, you're going to clean my house once a month for the whole term, which is 1 year. And the value that we know what the value is, just say it's Julie's business. We know that she gets paid $350 every time she cleans a house.
Okay. Can she have the loan without it?
Well,
you do the loan without that.
She wants the loan. She actually offered it to me because she knew I was making 35%. She came to me and said, hey, Steve, here's what I'll do. I'll sweeten the deal. I'm so thankful you're saving my butt. 26%, no problem. You're saving me. What a great guy you are. And by the way, I'll throw in cleaning your house once a month.
That the question is, can she get the loan from you without that?
It was her offer. I accepted it.
You didn't answer my question.
Because I wouldn't dare answer that question if I was being deposed.
Okay.
She offered it.
I'm going from what the statute says.
I was hedging. Okay. Mm-hmm. I'm hedging.
I had to buy a kidney off Temu.
That's what it was. $5,000 kidney on Temu. I was hedging 26%. I'm making 35. I'm like, oh, Julie, this is killing me. This is killing me. Hey, I'll throw in cleaning your house once a month. You know what, Julie? How could I say no to that? Awesome. You clean my house once a month. I will go ahead and we'll just have a separate agreement. We'll have a little contract for a year. I'm just not going to pay you. And that's just for part of this loan. How about that? She offers it to me because it's just pushed me over because I'm struggling here. I can make 35% of my $5,000,
Okay. This is the way it's described.
Okay.
It shall be usury and unlawful for any person or for any agent, officer, or other representative of any person to reserve, charge, or take for any loan, advance of money, line of credit, forbearance to enforce the collection of any sum of money or other obligation, a rate of interest greater than the equivalent of 18% per annum simple interest, either directly or indirectly, by the way of commission for advances, discounts, or exchange, or by any contract, contrivance, or device, whatever whereby the debtor is required or obligated to pay a sum of money greater than the actual principal sum received, together with interest at a rate of the equivalent of 18% per annum simple interest.
Period.
Period.
Do me a favor. Run my APR. Cleaning bill 350 times 12. Add it into the total interest. Back into the 5,000. What do we got?
We got Steven now has to clean my house for 12 months without the goats.
That's $4,200. Is that $4,200? Yeah. Right?
What?
350.
350.
It's 700
Right.
times 6.
Okay.
So that's $4,200.
Okay. 42 plus the 13.
Yeah.
What's that?
What's that? Charging, what rate are you charging?
26.
20. You're charging 26%. Okay.
He's about to put me in jail.
And you're $5,000, right?
Yeah.
So what is 4,200 divided by 5,000?
Oh, what's 42? What?
4,200 divided
by what?
5,000.
5,000. Right. 84%.
Okay. That's 84%.
Okay.
Now, this is a 1-year loan?
Yeah.
And you're charging 25%?
26.
26. Okay. Your loan is 110% for calculation purposes.
So what could you do to me as an attorney if Julie came to you?
Years
Years up. Julie just doesn't have the money, but I become a real butthole, and she's like, I'm going to get an attorney to protect me.
I'd give you the opportunity to bow out real fast.
Like how?
Like, you cancel her debt, and we promise not to talk about it to everybody.
So in other words, give up
on
your
a radio
$5,000
show with your real name.
Yeah.
Or podcast. Okay. Because that's 110%. Now, to get let's talk about a real kind of loan. Okay. Let's look at, so for calculation purposes, all right, let's say I have a 10%, $10,000 loan. Okay. The interest rate's 15%. All right. And it is for 5 years.
Okay.
But I'm going to pay $1,000 fee.
Okay.
For that loan.
Okay.
So, what do we have here? We have a 10% fee.
Okay.
We're paying 15% interest.
Right.
But in order to do the calculation,
I get to spread that 10% over the 5 years.
you pay, right? So that's 2%, right?
Right.
So for
Right.
and it makes it very simple. So we're
Right.
at 17%, and that is legal. That's perfectly
Okay.
fine. Okay.
Yeah.
Okay.
And so the length of the loan does freaking matter.
Oh yeah, but let's reverse it. I
Okay.
got a $10,000 loan.
Mm-hmm.
We're going to pay $1,000 for it,
Okay. Loan fee.
a loan fee. The interest rate is 0.
Okay.
It's due in 90 days.
Okay.
Well, what I'm paying is 10%, right?
Yeah.
Okay. And 90 days. How many years is that?
Oh gosh. Well, that's definitely one quarter.
One
of a year.
fourth of a year.
Yeah, 0.25.
So I'm going to divide by 25%. Well, when you divide by 25%, you're really multiplying by 4, right?
So the
Interest
APR
rate
would be
It's 40%.
So you can't do it.
wow,
So time matters,
a whole heck of a lot.
right?
So our deal with if I went back to the $5,000 example,
Extend.
and I still want 26%, so I'm still pushing it there.
Yeah, you already.
Yeah. But if I had a term of 5 years,
You'd still be at 26%.
I'd still be 26%, but
But
I
you
could take
take-
that 1 year for cleaning my house and split over 5 years.
Well, you'll be taking that 80%, 84%, and dividing it by 5. So you're still at
Way high.
27%.
Right.
almost 21% plus the rate.
25%. So,
So
it's still,
you're still-
I'm still
You're
screwed no
getting
matter
close.
what in that
You're
example.
still at felony level
Right.
usury.
Okay.
It's called loan sharking at 45%.
Okay. And then no matter how much you're trying to help somebody, you know, the interesting thing is you get somebody who's desperate for money. They come to you, promise you the moon, the star, and the suns if you'll just help them out.
And once they get out of trouble and that stress is gone, they will sue you.
And they will go to a good attorney. And because the borrower brought you the deal, doesn't change the analysis, does it?
No. If it becomes part of if it's part of what you're
No, I
promising
came
to pay,
you with the deal.
I know.
I'm willing to pay 26%. I'm willing to give you $10,000 up front. I need $1 million.
Uh-huh.
Okay? If I do that and I'm desperate, I'll give you everything you want. Not just you want. You didn't even say I came to you with the whole deal.
Well, remember at $500,000, you don't have usury at over 18%. Your
It's
usury rate is
25.
25.
Right. But if I have
But it's still criminal usury immediately, and you lose the principal.
so if I have a $10,000 fee I pay up front, I'm willing to pay you. What is it?
On what?
On $1 million.
Well, that's you said how much? $1,000 fee or $10,000 fee?
$10,000.
Okay, that's 1%.
1%. I'm willing to pay you 1%,
Plus what interest rate?
25%.
That's 26.
Okay. What can happen?
You can
Yeah,
lose
but
$1 million.
But I came to
I
you.
don't care.
I came to you and asked you to help me out.
If you got $1 million,
Mm-hmm.
you may want to talk to a lawyer first.
Because this person that promised you the sun, everything, because you need
Once
your
the
help,
okay.
I could then go to my attorney and go to you and sue you. And even though I brought you the deal, you would lose out.
Okay. Again, if it can be shown,
It wasn't
That-
you didn't make the deal. I did. I'm the borrower.
you
I came
could-
to you with
wait
the
a
deal.
minute. Well, why not just say, how about this? I'll just loan you the money at straight interest rate.
No,
That's not usury.
Listen, you're sitting back, have no need for this deal. I just happen to know you have the money, and I come to you wanting to give you a whole bunch of good stuff because I want you to help me out. So I come to you with the deal. 25%, $1 million, $10,000 right now, and I'll pay you back in a year. I brought it to you.
I don't care. You're still charging more than you're allowed to.
And so the point is
If you're,
you could lose your $1 million.
You could. Now, I think there might be some wiggle room. Okay, it's not supposed to be draconian. We're wanting to. The idea is to punish for charging and trying to get more than what is allowed. Okay,
And if it's under 500,000, 18%
right,
is all that's allowed.
right. But that's a civil thing. Okay, but when we go criminal, it changes the dynamics where you can't even collect the principal back, and that's like the ultimate.
Well, it's heavy
Sanction,
duty, man.
right? Not only is it a crime, it's not that. I mean, it's a misdemeanor. The most you could have is a year in jail and $1,000 fine.
At one crazy time in my life, this was prior to 2008, 2006, I used to think, as long as you disclose, that's all that matters.
Yeah, I wouldn't do that.
If I disclosed you, no, I'm saying obviously I don't
Yeah, but
think I
here's
would
the
anymore.
other thing: how many truth in lending statements are you going to have that show 60, a 30% interest rate?
True.
The only people that do that are those who can do it legally, like credit card companies. Right.
Right.
So we have the rules for a reason. And here's the thing: if the trickier you try to get to make the deal work, the worse it looks.
You
Okay?
mean to somebody if it goes to court?
Well, yeah.
Yeah.
Well, I'm not going to come to you and say, "Hey, you chose your criminal usury, so we don't have to pay you, and you have to go away." And you're not going to just take that laying down, are you?
No.
Okay. So you're going to have to go to court.
Yeah, but what you're telling me is they're going to lose.
If the intent that's necessary is shown.
Yeah, but see, that's such a tricky thing. If I come to you with the intent to defraud you as a lender, meaning I know the rules. I know that if I have $1 million loan from you at 25% interest and I pay you $10,000 up front, I know I can get my loan for free. And I come to you taking advantage of your ignorance. How's that going to go?
If I could prove that you knew you were charging more interest than you're allowed to charge, that would be the requisite intent. This is not a strict liability crime. Okay? You understand what strict liability means?
Explain it.
Strict liability is, I don't care what you were thinking. I only care what happened. Okay? The way it was explained to me in law school is used to be that statutory rape was a strict liability crime. Okay? The person's underage. I don't care if she had a driver's license that showed you she was 26. If she was under the age, it doesn't matter. It doesn't matter what kind of a person you are. It doesn't matter your intent. It doesn't matter that it doesn't matter that she instigated the event. It only matters that she was underage.
Okay.
Okay. So you want to protect yourself, cut her in half, count the rings. Okay. You've got to know the age.
Sometimes
Is that a rustyism?
that's a rustyism.
Okay.
That's how you
In
do it.
other
That's what you
words-
do with a tree.
Know their real age is this
Yeah,
point.
I know.
Okay.
I know.
Okay. Grab their femur, and there's a way to figure out how old somebody is. I don't know. Too many episodes of Bones. But I'm just saying, you cannot, if it's a strict liability crime, it doesn't matter why.
So, is this a strict liability crime?
No, it's not.
Okay.
You have to have intent, but the intent is to charge more than you're allowed to charge.
But if it is, and I'm sorry to beat this dead, but I really want a firm answer from you. If I, as the borrower, and
If I
that's
set you up,
I mean, listen, you prove it, right? How can you
well,
prove
who's
it?
the sophisticated party here? Okay.
That's what I'm thinking. Most people who need to borrow money are the ones coming to someone who can lend the money. You're not always finding the people. So at that point, when you become the bank, you therefore have to put on the hat of knowledge and be responsible.
But if you don't know, and this
then you,
friend
shouldn't,
of
don't
then you
yours,
you
shouldn't
know?
be lending.
this friend of yours comes to you and says, "Hey, I'm going to 26%.
Yeah.
You
In
know,
the back of your head,
20,
you know it's wrong.
20%, 26%, and I'm going to give you
Yeah.
$10,000 right when you loan me the money." And you don't know any better.
Have you ever heard the phrase "too good to be true"?
Mhm.
Well, listen though. And then the borrower, a month later, says, "I'll fix this, fix his little red wagon."
I don't have any cases I can look at to see that happen.
But could it happen?
It could. I think it'd be interesting to fight with, because again, you got to show the bad intent.
Right.
Okay?
And I think that's the key.
And so, the case that I was working with the bridge loan people,
Mhm.
I was very disappointed because they dismissed the case right before trial, and because I don't think they wanted to go lose at trial by usury, and the interest rate they were charging, from my calculations, was about 40%, and that's the loan where it's an 87-day loan at 0% interest, but there's about
There's fees.
10% on fees now, but they try to call that fee something else. Okay, they were calling it a fee to remove a financing contingency from a real estate contract, because they were going to buy the house from my client if my client couldn't sell it themselves. But they were loaning him the money to get their new house. Okay, it's a bridge loan.
Right.
But the way they do it, they would charge you, it was almost 8.5%, just to say we're removing the financing contingency from the contract, because they say they're going to buy the house. Okay, the idea is you have a no contract house sale, so you can qualify for your new loan. But they charge that, and then they have other fees. Well, on the loan amount, that comes out to
Yeah, but
10%.
the seller, we'll call him the seller, because it's a weird situation. Not only are they the seller, they're also
the borrower.
the borrower, which
Right.
is a weird scenario.
Well,
But they needed the money.
They need the money to get the new
and
house.
they need to get the new house. But why all of a sudden we don't like this deal anymore? Let's hire Rusty Collins to fight with them.
Well, because here's the thing. It was due in 90 days. and it's structured to where there's a 2.5% fee extended another 90 days.
They, as the buyers, would pay that
the
fee.
lender. Okay, you'd pay it on the payoff.
Okay.
Although it doesn't say it that way, but that's what they do.
Okay.
They never attempted to close on the purchase. In fact, my client said, I called them up and said, why didn't you guys buy it? Oh, we don't buy houses. We're under
So
contract.
they're alone.
Okay.
It was just a mortgage.
Okay. It was just a loan. And they use, it's not Fannie Mae type documentation, but it looks a lot like it. Okay. Mostly standard stuff, except the interest rate was 0. And it was very obvious that they were using a contrivance to exact more money, because after the 60 days or after the 180 days, interest rate goes to 18%, the default rate. Okay.
Who was trying to sell the property? Was it the sellers or was it the
Well,
new owner,
the client,
which was the lender?
No, the client was trying to sell the property. However, when things, this was right before there was a market correction. See, they offer you money, and if they were to buy it, they set it up at the beginning to where there'd be equity, right? So
And there's no equity, so
there's no equity, so they're not going to close.
it sounds a lot like these access your home equity deals.
Oh gosh,
Home tap.
It should be home trap.
Home trap. So I mean, that's what it sounds like.
Well,
And they're
that's
advertising these. They're advertising this like crazy right
they are,
now.
and here's
It's
the
not
thing.
called a home equity loan. It's not called a mortgage. It's called tap into your equity. I mean, what the heck?
Okay, on something like that,
Mhm.
the devil's in the details.
Right.
Okay, I was asked to review one of these deals for a friend who I was in a band with. Okay, he's older than I am, but not ready for a reverse mortgage. Okay, and I got the documentation. I went through the math, and it did make sense for him with the math.
Really?
It did. And I was able to tell him that while I probably wouldn't do this myself, this is what it means. This is where you'll be at a certain period of time. If you believe that market value of your home and you can sell it for more, okay. This is not a flim flam. It's not a sham. It's not a trick. This is what these documents mean. And I'm good with a spreadsheet, and I know how to do financial calculations, so I can figure out what it would be. How much is it costing you? And it's basically kind of like a loan with no payments, a small reverse mortgage that you pay off at the end instead of dying first. Okay. So it is a product. That product was one that made sense for my client or my friend who I was representing to do that. I've not seen anything with Home Tap or any of the other parties that do this.
We need to check into those and just see what they're like.
I feel like they're really pushing it heavy, and
Yeah, that's big right now.
And if you're doing something like that, if it's the one I saw was 10 years to pay it back, and they're calling it equity sharing or something. If that exacts interest that's higher than 25%,
we're gonna have a lot of fun little lawsuits.
Well, I don't know. I haven't done the math, so I don't know what that means. And again, if you're basing this on some future event that you can't predict right now, that you have the risk, you're accepting risk, and both sides are accepting certain risks,
Right.
and that's probably not going to be usury.
Okay.
If it's based upon something unknown later that has not happened yet.
Let's go to homes. Okay, let's change the scenario where Julie needs that $5,000 because I want to stick to that. But I'm like, I ain't giving it to you unless it's a mortgage on your homestead. What are the limitations on people's homestead properties and the rates? Is there a difference?
There's no change.
Okay, so 18% is still the rate.
18% now.
And that has to be an annual percentage rate, which means the rate plus fees cannot exceed 18%, right?
Right, when annualized. And that's the state deal, okay? And again,
what about federal?
No, well, that's the state way to calculate it. That
Okay.
does not always come up to be what you would have as APR in a disclosure statement. Okay.
APR is APR, dude.
APR has a legal meaning.
Yeah.
Okay. The way it says in the statute is 18% annualized.
Which is APR.
There are certain fees that you pay that are counted as prepaid finance charge
Yes.
for APR reasons.
Yes.
Okay.
That you don't count for annualization.
Right. Because, okay,
So annualization rate would be
it's a fee for the
lender
loan.
fees, period.
Fees for the loan. In other words, can you get the loan without paying this fee?
Well, but see, a lender's going to require title insurance.
Right.
So I mean, I don't
But
think
they don't. But the lender doesn't get it, and it's a normal closing cost to insure
the
the
lender
title.
doesn't get it.
The lender doesn't get the title premium.
No.
Okay, but in many instances, the closing fee is considered, and now some mortgage brokers hedge on that. Okay, they'd rather over disclose than under disclose, and I've read the rules for this, and the closing fee is APR, or part of the APR. The attorney's fee, like I prepare mortgage documents for a mortgage broker, they're requiring that they use me to do that. It's a legitimate fee. Nobody's getting gouged. It's not.
Well, I don't want to get in
But the
the
point is-
weeds, but I want to say so. The rules apply whether it's and I call it consumer debt, and that's just the word I use.
unsecured debt.
Unsecured debt would be the word.
Unsecured
Whether it's
consumer
unsecured
debt.
debt or secured debt, it doesn't matter. 18% is the number. Period.
Right, but
the state of Florida.
But here's the thing: if you're refinancing your home that you live in, and you are considered a lender, meaning there's not an exemption for you to be a lender, like you've made more than. Well, actually, if it's what we call Section 32, because it's a statute or a rule that ends in .32, but if you make one loan that qualifies, you're a lender.
Okay.
So your maximum interest rate is a certain Fed rate plus 8%.
And
That's your
so
maximum
that's
APR.
so that's where it changes.
Right. So it's less than 18% typically.
All right. And the Fed rates right now, whatever they were, I don't know. Safe. What? 4?
5.
Somewhere.
I don't think they're 5.
Okay.
Yeah. But let's just say the 4. The 8% to 4.
It's be
That's the
12%.
max. If you're considered a lender.
If you're considered
That
a
means
lender
you have
and it's
more
a
than
high
5
interest rate
loans.
loan.
Now that's not 5 loans.
No.
What is that?
If you make a higher interest rate loan, the first loan makes you a lender.
3.7.
Oh, really?
Right. You don't get a free pass.
Okay. And so I guess if the Fed rate was
It's 3.75 right now.
So
that's 12%.
right.
Interesting.
So that and again, there's other rules that apply too, as far as closing costs and.
I think the thing
qualifications.
to remember is don't be doing mortgages without an attorney or
If
a,
you're going to
a
loan
mortgage
money,
broker.
you remember you're taking a risk.
Yeah, but if you got
Okay.
collateral, that risk is acceptable for the most part if the collateral is right.
If the collateral's right, yes, but if you're a lender, you can't just loan based upon equity. The person has to qualify.
Okay, but that's for home. Now, unsecured debt, that rule doesn't apply.
Not that I know, not in the state, because I'm not worried about the state there. Because with the mortgages on home, you got state rules and you got fed rules.
If you become a lender, you fall into Fed rules,
Correct.
right? And that's more than 5 loans, or if you do a high interest,
I thought it was
A
more than
Section
3,
30.
but
doesn't matter. All right. One other thing I want to talk about mortgages, and I know we're beating mortgages to death today, but seller held financing or any type of financing. We talked about this briefly. We had a transaction where one of my customers came to my office. He was buying a home from a seller, and the seller, it was very important to the seller that in the 5 years that this mortgage was going to balloon, that the borrower, or in this case the buyer, could not pay off the mortgage. He had specific reasons for wanting that.
Right.
Now, in my opinion, I said, I'm not an attorney, but I don't know if anywhere there's any rule that prohibits a borrower buying his primary residence on a seller-held mortgage that can force the borrower to lasts the 5 years. You can have a prepayment penalty, but I don't know of any rule that requires that mortgage to be in place for those 5 years. You are saying I'm wrong.
I'm saying you can contract for that.
How?
Very explicit words
How?
on the note.
You can't tell me that some dude, he wants to pay off a mortgage, he sold his house, he had to get relocated to Alaska for whatever reason. He's lived there for 2 years, now he's got to sell his house, and you're telling me he can't.
Well, he'd probably have to have something where he could assume somebody could take over the payments. But here's the thing: what does the seller held financing person want?
The interest.
He wants the cash flow and interest, right?
He wants interest, and he wants some type different tax liability. His tax liability changes in 5 years.
Actually, his tax liability changes in 1 year.
Well, his tax liability changes in 5 years.
Well, he may have different income. I'm talking about for the transaction.
So don't you just build a prepayment penalty to
That's what I would think.
Well, that's the
in your
easy way to
favor?
do it. Now, when you have certain kinds of large hedge fund or certain kind of specialized financing in real estate for a big project, your investors are looking for return on their money over a period of time. They want the 5 years. They want the 10 years. They want a 30-year bond, whatever. If that keeps the borrower from being able to advance what they're doing, they can replace that lien with security, can't they?
Yes.
Right. And how do you do that? Well, you can buy an annuity. You can buy a bond.
Okay, but you
Something
can't,
that pays.
But you
that
can't
same money.
force a person.
You can.
It's a lien, Rusty.
Right.
They don't have that ability to say you can't pay me off. It's a lien. You're gonna have to show me somewhere where that you can.
You
prove
can
that.
take all of the payments that the person would get
Mhm.
and set it up with a bank where it's 100% secure to get the money monthly. You
But-
convert the lien to security.
But if you take the interest for 5 years, and that's a hefty prepayment penalty, dude.
True.
So I don't know. I disagree
That's
with
not,
you on that.
and that's not, that wasn't.
I
usually.
think you're going to have to find some other documentation
There's-
because I think you're
there's
smoking
case
crack.
law.
Well, we're going to have to talk about some other time because I don't see how that's even feasible.
It doesn't happen very often. It can't be assumed. It can't be assumed that that's the case because if you don't talk about it, there's no prepayment charge, right?
Right.
So we like our loans we like things to be freely alienatable. In other words, you can sell your property, right? So there's a way to get around it by taking the cash flow and turning it into something else that's just as secure. And you
can document all that within the mortgage.
yeah. You can
All
say you can pay off early, but I get all my payments.
Let's talk about something different. This is something we briefly talked about on the show before. When is a marriage certificate legal?
Okay, what is your definition of a marriage certificate?
A marriage certificate is a marriage certificate.
Is that something I make if I perform a
No,
wedding?
no. Let's say
We're talking about the
a
license?
marriage certificate, the marriage license.
Okay.
You go down to the county, you pay your fee, they give it to you. They tell you, sign in black, get a notary or preacher, whatever.
Somebody
it
who
is.
has a
Yeah.
legal authority.
Legal authority to do it. And you go off, you're with a bud, a friend, you have some pastor there with you, and you do the ceremony.
Or you stop by the UPS store and say, "You got a notary here?"
No, hardly no witness, nothing.
You don't need witnesses. You need notaries.
I know. We have a notary.
Okay.
When is the marriage legal?
When the parties enter into the marriage contract in front of the notary or the officiator that has legal authority, and that's done under a valid and operating marriage license. That's when it's valid.
The recording doesn't make that valid.
The recording does not make it valid.
The recording only places it in public record for public notice.
Right. It doesn't. Let's put it this way: if you get married and somebody loses the signed document It goes through a shredder because I've had original notes go through a shredder.
Oh, so not fun.
Well, when you say you have it, and then you say, "Well, Judge, I had it," and then somehow it got in the wrong stack and was shredded, and they were like, "That sounds like that could happen."
Yeah.
Okay, but it doesn't mean there's suddenly no marriage, right?
I agree with you.
I mean, what is the marriage? Is a contract?
It's going to be interesting if notary's dead. Okay.
Okay.
And one person says to the other,
Just joking.
prove that we're married. You can say that we had a ceremony. I want to say that we didn't.
Well, proof is in the pudding. You got to.
It'd be an interesting dilemma.
Well, okay, but what matters is, did you enter into the contract?
So,
And was there a license?
this is why we have public notice. This is why we have a courthouse.
Right.
To place things.
We want it recorded
because when does a deed become legal?
when it's delivered.
So explain what that means.
When
Use you and Julie as an example.
okay, so you go to a closing, you execute the documents, the money,
deed.
You execute the deed.
Right.
Money's been paid.
You as a seller execute the deed. Julie's the buyer. She hands you the money.
That's it. We're done.
Deed is witnessed and it's notarized.
Right.
Witnessed.
Well, it's just witnessed.
Witnessed. Okay, just witnessed. Property is now Julie's.
Hers. Right. That is the
Okay. So we close on a Friday, but you don't file it until Tuesday. It's still legal on Friday.
you're the owner
Right.
when the deal is done.
Right.
Okay. And again, think about it. We do lots of mail away closings.
Mm-hmm.
The person signs the documents in another state and sends it here, and it gets 2 days before closing.
Mm-hmm.
Okay. Well, the property hasn't changed hands yet.
Mm-mm.
It's still the seller's property. Okay. The borrower comes in and signs all the papers and has paid her down payment, and she has a mortgage. Is the deal over? Well, depends. Do you need a funding authorization from a lender? At the point that everything is done, that's the magic moment where delivery is complete and property has magically changed hands.
Even though it's not recorded.
So even though it's been witnessed, let's just say it got lost through the cracks and was never filed. It was discovered a year later. It was never filed. It still goes back to the day that the notary witnessed it.
The transfer happened when the deal was over. Okay.
So the same thing with the marriage certificate. It's when it was done with the notary,
Basically,
whether
yeah.
or not it was filed.
When
Don't say basically. The answer is yes.
Okay, yes. Okay.
You know
Yes,
he
thank
can't.
you.
There's
Oh
always
my
He can't
gosh.
do that.
It's such
I
an
have to
attorney.
hedge, but
You don't have to hedge when it's just black and white. Is it official when the notary stamps his stamp on there and the two people get married, sign?
the people who got married don't have to sign that document. They already
Just
signed it.
saying is it official? The answer is
If the officiator has authority.
just say yes.
If it is
It's not
a
gonna kill
valid
you.
and
Yes,
active
all of that's
license,
yes. Then yes.
I don't even care what your intent is
Okay.
at that point.
Point.
Because
But
you
on a
entered in
deed
the contract.
But on a deed recording, that's not what makes the transaction official. It is the exchange, the acceptance of the deed, and the payment for the deed,
Right.
and the witnessing of that exchange with witnesses on the deed because the statutes of fraud.
Right, we have to have
sign.
witnesses.
Right. We have to witness.
Okay, but this is
And
really
we put a notary on it for recording purposes.
right.
Okay. Now, closing's official. Close it Friday at 1:00. Then we have a seller who's really savvy. He goes down to title company B, and he also sells the property at 3:00 and signs, witness, funds are exchanged. He's already got both wires sent to his bank account, and he's verified both wires. Who's the owner?
Second person.
Okay. I know. See,
okay, yes.
this is one of these law questions.
Okay.
that- I'm going to use the
I
word.
would've
It
lost
pisses
that
me
bet.
off.
This is
Why the second?
because Florida is a notice only state. Okay?
This
So-
rule will drive you freaking crazy, but it is true.
Okay. Hold on.
Actually, more lawyers get the answer to this question wrong than title.
Well, I get it. No, title people get this wrong all the
here's
time.
the thing.
We're all about the first person to record their deed wins. Well, it's true because the 1 o'clock person had the duty to record that deed at 2 o'clock.
Well, if you want to protect yourself,
Yes.
meet me at the courthouse.
Right.
I'll hand you them. I will have checked it down, and there's nothing else being recorded right this second. And if you're still the owner, I'll give you the money. You give me the deed, and I record it right then.
Right.
That's how you protect yourself. Or the title company takes a
Well,
certain
this
risk.
is why you don't buy without a title company.
Right.
Yeah.
The title company's assuming a lot of risk.
Yeah, we do.
Um,
Oh, I know you do.
We're in a black zone. You know, when people do closings, we're taking a lot of people at the word.
Yeah.
Which, you know, that's a perfect way to do things, right? But that's what we
Nobody
do.
ever lies. But
Nobody ever lies. No.
so
Nobody lies.
the key here is notice. And my
That's crazy.
way of doing was
Well, and I want to explain something. The closing that took place at 1 o'clock had the duty to record.
because that gives the 3 o'clock person notice.
Because the 3 o'clock person without the notice of the 1 o'clock closing is now
Wins.
the owner.
Now, because
How's that for
because the
going
1
to
o'clock
And how do you
closing
submit?
had the
By
ability.
email? How are you submitting and how are you getting confirmation of the submission?
Well,
There's
It's
we
not
got-
the
recording.
submission; it's the recording.
Okay.
it's when they stamp
When they stamp
recording.
it, but they don't do them right away.
Well, there you go. You better run down to the courthouse.
I am from now.
Now, with the recording, once it's recorded, everybody has access to it.
Right. It's
Okay.
notice.
It's notice to the world of the transaction, and it's the 1 o'clock closing that had the ability to prevent the fraud for the 3 o'clock person.
That is a tight window, though. So what happens if both of them show up on Monday or whatever,
To record
and
the
the
deeds.
1 o'clock is received first?
No.
It doesn't matter.
I don't care which records first.
Really?
Who took last without notice? Okay, so in my
I wish
example,
that's-
when we first had this argument with him, I thought he was freaking smoking crack. I thought he had lost his marbles. He was nutsos. It went against everything I ever understood about real estate, risk, recordation, and all that stuff. But actually, when you boil it down, notice is everything.
But there should
Right.
be a grace period.
There
should be
is.
you
There
go
was 2
to the
hours.
courthouse. No, you go to the courthouse. You go to the courthouse and record as you pay. Okay,
Yeah.
that's how you do. That's how
But,
you.
but we
prevent.
have title insurance because this is not feasible. It's not even reasonable to think that that's what people are going to do. So this is why you have title companies
There's a
like
risk
us.
that's accepted.
But now all of our audience knows this.
Well, this is why we exist.
Yeah.
Because this risk right here is real.
Mm-hmm.
And the example that I use, I have the one closing at 9, the second closing at 10, and then at 11 o'clock, the first closing records, and then at 12 o'clock, the second closing records. Who owns the property? It's the second person.
closing.
Even though they recorded
First.
second.
No, even though the
recorded,
second, even though the first closing recorded first, they don't own
But
it.
it was after the second closing happened.
Yeah. Isn't that
And
crazy?
because, again, it's without notice. Otherwise, if you have notice, again, if you buy a piece of property, you're out of town, but there is a tenant in the property, you don't really know about them, but because they're in possession, that's considered notice. So you're subject to whatever the deal was that the previous
Yeah,
person
no, I
had.
get that.
Right.
Okay? Because it's notice. We are strictly notice in Florida. And
Which I love, by the way.
it's very
I
simple
think
to understand.
Florida laws are great. I think Florida laws are wonderful with their homestead rights. Kind of call it homestead rights.
You're saying
Statutory homestead rights.
constitutional homestead rights.
Constitutional.
homestead rights. Thank you. Which is different. You're right. Constitutional homestead rights are, with judgment protection, things like that. When we deal with estates when pertaining to marriage and, tenants by the entireties, you go to Idaho, spouse dies, you got to probate their estate.
Right. We had to sign paperwork for my father to sell the property that he and our mother owned. We had to sign probate paperwork, and I think we even signed a deed somewhere along the line.
Yeah.
Okay, because,
All because
our
it
mother
was in
died
Idaho.
without a will, so
It was intestate.
it was intestate.
Mm.
If it was happening here,
Dad would have owned it.
well, yeah. Well, if it was homestead,
Okay.
though, here, we would have had a half
No, it
interest.
doesn't
rate.
matter. If they own it together, it doesn't matter.
Right. If
You don't even have to put husband and wife on the deed.
You don't.
If you don't state that they're not husband and wife, then they're assumed to be husband and wife if they are. And if
If-
you're married and you take title of the property and you don't state anything, it's automatically assumed as husband and wife. if that's what you were.
Well,
And you don't have to put that on the deed.
right.
And title passes.
Title passes like it's supposed to.
Right. I love that stuff. I think Florida's great. So this whole notice
there's
thing,
some
even
protection.
though when I first heard about it, it freaking almost sent me to
Well,
drink.
remember, from the time
I
you
did.
started,
It's time for me to start taking up drinking because I could not comprehend the insanity where a notice date. The first deed recorded placed everybody on notice. No, it was the second person.
but think
that
about how
purchased.
you were trained in the title
Yeah,
world.
I know.
You're
I'm trained
talking
in the
about
title world.
risk,
You're talking about risk.
not the law. You're talking about risk. And we had the closing. We got to get it recorded. Got to get recorded.
Mhm.
There were certain. If we closed at Barnett Bank, which at the time was across the plaza from the courthouse downtown,
Yeah,
in
we were
Santa
right
Monica,
Across from Flagler College.
you would
yep.
leave.
Mhm.
They would sign the papers. They would not disperse. They'd give you a check to record, but they would not disperse that deal until you went across the street, checked it down, recorded, and came back.
Right, the
knowing
old
you
Casa
would-
Monica.
Mhm.
Right.
No,
That's
I
where the
know.
courthouse
I
was.
used to do
you had to
withdrawals
come
there.
back with them knowing that you recorded. You had to have the recording numbers because you didn't get the document back right then.
Mhm.
You'd have to have that before Fred Rice would disperse. Now, that was
Back
ingrained.
in the day.
Okay.
And we would sit there and go to the courthouse before
And
we
look.
recorded anything, and all the stack of stuff that got recorded today, we're looking through all those documents, making sure we don't have any conflict. It wouldn't have mattered.
Wow.
No, well, we do that before the closings in some cases.
In
but
some cases, we would.
I'm just saying because that stuff was not indexed yet.
no.
So, what we used to do, we were trying to minimize risk. So when you're indoctrinated with that, and somebody says, "No, it's the last person to take without notice wins." You're like, well, then why am I trying to record so bad? Well, we're trying to record because we want to.
We might be the first closing.
We want to be the
Right, yeah.
person.
Right.
We want to give them notice by recording.
Right.
Because we don't care if they actually know. Now, in our scenario, if you leave the closing number one, leaves and sees the person coming in for closing number two and says, I just bought this house,
There's notice.
then there's notice. Okay.
Okay.
But no, Frost is going to do it in the same place. He's going to go to another title company.
Of course. Yeah.
Right.
Because it'd be hard to close the same house twice at the same title company.
Yeah, it would be. At least you would hope
I hope
so.
you have different closers.
All right. Well, those are basically all I really had for you today. I just wanted to go over these points. So appreciate you going over that with me. Julie, thank you for always being with us and adding to the conversations. This has been Land Title Talk. Again, thank you for listening and watching. We appreciate your contribution. Remember, you can always text me at 904-501-4481, 904-501-4481 about anything, and we'd love to help you out. And we're also a title company. This show is actually sponsored by Land Title of America. We want to help you with all your real estate closing needs, whether it be refinancing, selling, buying, all of those real estate transactions. We want to be there to help ensure that transaction and protect you. One thing to remember also, if you inherit property, I think it might be wise to get a title policy, something you can talk to a real smart attorney like Rust-Oleum over here about. And so keep that in mind. And Rusty, how do people find you if they need you?
Good luck. 904-829-6600. Hopefully somebody in my office will answer the phone.
904-829-6600 and ask for Ben. Don't ask for Rusty, ask for Ben. And thank you for listening. We will see you next week.